Well, I'm showing we're live on YouTube. I haven't received a message yet from Chelsea, so I'll go ahead and welcome everyone. My name is Melissa Standridge. I'm the presiding judge for this special setting. This is Raymond Kamila, is that right?
Yes,
Kamila?
Kamila.
Okay. Kamila. Raymond Kamila versus the University of Kansas. With me today on the panel are Judge Gordon Atchison. Gordon has been on the Court of Appeals for 9 years, and we're very thankful to have with us today Judge Jim Burgess, who was a Sedgwick County trial court judge in the district court for 24 years and has been sitting with us as a senior judge for a little bit over 6 years. So that's your panel today. I guess I should say I've been on the Court of Appeals for a little bit over 11 years. We have read your briefs, and we also have attorneys that work with us who have written a pre-hearing memo. We've reviewed the record. We're very familiar with the facts. We're familiar with the law. So it's up to you how you want to spend your time on argument, but we do know the facts and we're interested in what you have to say regarding your position. Each side will have 15 minutes, and after you introduce yourselves and state your appearance, at least for the appellant, I'd like to know whether you would like to reserve any time for rebuttal. If so, I will be keeping time, and I will let you know as that time approaches. We normally get our opinions out within, well, we shoot for 60 days. Well, we shoot for 30 days. We get in trouble if it's 60 days. We shoot for 30 days after oral argument, so we shouldn't take too long in getting this opinion out. With that, I think I've covered all of the housekeeping. This is our second argument for the Court of Appeals, where we are doing argument by Zoom while simultaneously broadcasting on YouTube. But starting in July, we are going to be doing regular dockets. So at least a dozen cases, maybe more in July. So although it seems kind of new now, we'll be old hat at it by the end of the year. With that, if the appellant would like to state appearances and let me know if you would like rebuttal time, well, we can begin.
Thank you so much, Your Honor. Good morning from me. I guess it's good afternoon to all of you. My name is Joshua Ritter. I represent Raymond Kamila, the appellant in this case. And just thank you for allowing me to take part in this historically unprecedented type of oral argument, especially in the backdrop of these truly troubling times. So thank you.
And would you like any time for rebuttal?
Oh, yes.
And do you want to introduce your local counsel?
Sorry about that. Yeah. I suppose I should reserve about 5 minutes for rebuttal if that becomes necessary. Thank you so much. And local counsel is Mr. Edward Foster, who I'd like to introduce.
Okay. All right. With that, you may proceed.
Thank you, Your Honor. Put plainly and bluntly, Mr. Kamila is a very lonely and awkward outsider with little understanding or appreciation for the social cues that many of us might take for granted. Unfortunately for Mr. Kamila, aside from leading to perhaps misunderstandings and trouble making friends in his personal life, it has also led to his unjustified expulsion from the University of Kansas. Our contention is that the university acted improperly in three distinct ways. First, the university overextended its jurisdiction, both by its own definition as laid bare by the legislative intent, and I'm putting that in quotes, behind its stated jurisdiction. And the university acted outside of the jurisdiction allowed under Title IX, which we do believe governs this kind of conduct. Secondly, the university did not provide substantial evidence that Mr. Kamila committed the acts that he is accused of. And finally, the university arrived at a decision that was arbitrary and capricious, given the improper evidence that was considered by the university and clear indicators of bias on the part of the investigators.
Before you get too deep into it, I have what may be a silly question, but I'm not super familiar with Title IX or these kind of disciplinary proceedings. What is the underlying legal relationship between Mr. Kamila and the university that allows the university to proceed in this case? I mean, is it police powers? Is it common law? Is it contractual? What is the legal relationship that allows the action to be taken here?
Sure. I believe it is birthed out of Title IX. Title IX instructs all universities receiving federal funds that they are to ensure that those who have access to the university are not somehow affected by sexual harassment. The Department of Education went on to further explain what that meant in this, what has now become known as the Dear Colleagues letter of 2011, which outlined several things that they wanted universities to get involved in. And I guess that, I hope that answers Your Honor's question. But
Mr. Ritter, does that mean that nobody was ever expelled before 1972 when Title IX was passed?
No, I imagine that they were, and I imagine those fell under the guidelines of whatever student codes of conduct they had at each individual university. But starting in 1972 with Title IX, it expressly gave them guidelines as far as how if they're receiving federal funds, how they should intervene in these types of matters, especially involving members of the opposite sex or things related to gender or sex orientation.
Well, in this case, though, is the relationship between the university and Mr. Kamila a contractual one? And is that the basis on which they can act? And in the sense that Mr. Kamila paid tuition, he was entitled to get an education, and I presume somewhere in there he agreed to abide by the rules and regulations of the university. And that's what he's being subject to here, are the rules and regulations, isn't it?
Absolutely. And I think Your Honor is correct that it does arise out of that contractual obligation as well as a contractual obligation to the complainants, the two women listed in this case.
KU would have a separate contractual obligation with them.
Correct.
Okay.
But on the first issue, with regard to the jurisdiction, we'll start with the Code of Student Rights. Your entire argument is based on the fact that the definition in the code under Section 2F is ambiguous. Yes. What language do you believe is ambiguous within the code, Section 2, subsection F?
Sure. So that outlines, or is the only part of the code that gives them any kind of authority to control off-campus behavior. And it says, when that behavior affects the on-campus safety of a member of the university community. That phrase there, affects the on-campus safety. Affects is an incredibly ambiguous word. We don't know if that, are we talking negatively affect? I imagine we are. Are we talking positively affect? Are we saying make somebody uncomfortable? Are we saying make somebody want to avoid them? It's ambiguous in the sense of what level of effect, what does that word effect mean, in order for them to take this, which the courts have already cautioned is, a great step outside of the confines of the university and almost acting as quasi law enforcement, that they're now trying to police activity that takes place off of the campus.
In your brief, you cite to the question and answers on Title IX and sexual violence that was issued by the OCR on April 29, 2014, and they use that exact same language.
I'm sorry. I'm missing your question, Your Honor.
Well, I mean, you say that it's that language is ambiguous, and we know that language was added in 2016, correct?
Yes.
Because you included in your materials the letter to the Student Senate, but in your materials, you also cite to the question and answers on Title IX and sexual violence. And you gave a link that I followed, and that was issued by OCR on April 29th, 2014, and they used that exact same language. So it looks like maybe KU pulled that language when the behavior affects the on-campus safety. It uses the effects language. Yeah.
Right. And I guess I would argue that it's ambiguous in the questions and answers as well. I think that's why the vice provost took it upon herself to write that letter, because it was ambiguous. Because if we're going to allow the university to take this giant leap from on-campus behavior to off-campus behavior, we have to understand what that word affects means. And that's why I think they outlined in that letter that was such intense violence that it resulted in substantial injury causing absence from classes. And that's where
you're butting up against your 5 minutes.
Okay.
Would you like to continue, or
you know what? I'll continue if you have further questions, but I'll go ahead and keep quiet if you'd like me to reserve that time.
No, I mean, it's up to you.
No, I'll go ahead and just close out my point here is that what they, by their own legislative intent, what I'm calling it, outlined certainly doesn't fall into the category of the conduct that we see outlined here. And I believe that by singling out one chance encounter at a library and hoping that that will bootstrap it to allow the university to act on campus on our activity that took place entirely off campus is inappropriate and not in lines with what case law and even Title IX has outlined as appropriate. Thank you.
Thank you. You'll have 3 minutes for rebuttal.
Thank you.
Mr. Leach?
Yes, Your Honor. Mike Leach on behalf of the University of Kansas. Thank you. May it please the court. University had jurisdiction in this matter on 2 separate bases, because the actions occurred on campus and because the actions affected the on-campus safety of members of the university community. And so in all the discussion about the effects, what the appellant tends to ignore here is the first prong, which is the on-campus behavior. There was behavior on campus that the university has jurisdiction over. And of course, the biggest of that incident was that the behavior directed towards Ms. Tapko, which occurred in the university library, at Anschutz Library. And so that is one element of the student code's jurisdictional language that gets to that behavior, where he went after directly being told to leave her alone, went from his Campus Christians organization off campus, on campus, and somehow magically arrived immediately at the table of his victim, where he confronted her looking very firm, frazzled, upset, and on edge to the point that she felt afraid that he was going to hurt her. Those events all occurred on campus, where he continued to pull her away from her friends, lead her away from her friends, and where they had a conversation where, again, keep in mind, he's just been told to leave her alone. He tells her, too much, too fast, don't want to have a relationship with you. He then follows her back to her table with friends. Again, all of this on campus as part of the behavior.
I don't want to divert you too much, but I would like to get your impression as well as to what the underlying legal relationship is between the university and Mr. Kamila that allowed the university to act in this case.
Well, and I appreciate that, Your Honor. Mr. Kamila is a student, or was a student, and as a member of the university community is subject to university policy. I don't
understand. My question is why? What is the legal relationship that causes him to be subject to that policy? Is it a contractual one?
He's an enrolled student.
Okay. And
as a participant in the university's procedures, he's subject to the student code and to its disciplinary machinery. Okay. I don't think there's any evidence of a contract here. The appellant asserted a breach of contract claim below. He hasn't raised it here in appeal. There isn't any evidence of anything that looks like a contract. And so I understand that the notion of a contractual relationship, there just isn't any evidence of that. And there isn't anything that at least I'm aware of in the record or otherwise, where a student signs up and says, it is a condition of enrollment, I'm doing this in the sense of it being a contract.
Okay, so I guess you think there's a separate legal relationship of student and university that is sui generis then, in terms of legal rights and obligations?
Yeah, I mean, I think it's a matter of being, I mean, somewhat sort of inherent authority, but it's not inherent authority to do willy-nilly, right? And the university has gone through its particular procedures and processes to adopt policies to govern student behavior. So it's certainly, as Judge Gentry's points out that the ability to discipline the student didn't arise in 1972 with Title IX, right? We've always had the ability to discipline students in a
Okay, well, I don't want to get down. I didn't mean to dig a rabbit hole here, so that's fine.
Okay.
Mr. Leach, I'm interested in just, is there a mechanism to challenge the severity of a sanction once violations are found?
Well, there's always the ability to challenge what the recommendation is. Remember that the IOA does its investigation in these cases, and it makes a recommendation to the Office of Student Affairs as to what an appropriate sanction in their view should be. And so the level of the sanction is an issue that goes before the hearing panel for live hearing, and the student is allowed to challenge and challenge the level of severity of the hearing at that stage.
Right, but I'm saying on review, we look for substantial evidence in the record to support the findings. But on a sanction, that's not really, we don't look for substantial evidence for sanctions because there is no standard for that. I just wondered whether, is it an abuse of discretion or is there just no law on that? Is there no mechanism? I mean, I just don't.
I understand. I don't think there is anything out there that would suggest the court would treat this any different than any other decision of a state agency under the KJRA. I mean, this really is a matter of, is it so wide of the mark as to be outside the realm of debate in the sense of whether it's an arbitrary and capricious remedy. I would suggest to you that the explanation for the sanction in this case demonstrates exactly why this remedy in terms of the expulsion and the ban from campus is not arbitrary and capricious. The Vice Provost explains very well that. Here is someone who's got two victims of his conduct in this case, and with a record of other women on campus who've made complaints about his behavior, and so the notion of someone who's been given an opportunity.
But let's talk about that for a minute, because the appellant says that it's a violation of his due process rights to use the fact that other people have complained. And it kind of sounds like, you don't have to meet the same standard to get a no contact order than to go through a full evidentiary hearing and have it determined that, that the facts are true. Is it a violation of one's due process rights to rely? I understand that the way it was written up, both by the investigator and by the hearing panel and by the vice provost, it was written up that those were only taken into consideration for purposes of the sanction. But is that a violation of due process? Because it's really just allegations.
Well, if it is, I would have expected to see a citation to it in the appellant's briefs, and I didn't see any of that. And so I'm not aware of anything that suggests that.
Well, no, he did bring it up in his brief.
I know he raised the issue, but I didn't see any case cited that said, oh, by the way, it's a due process violation. I don't do a lot of criminal work, and so I bet the judges on this panel have done a lot more than I
do a lot of criminal work, and you know what? If you don't have notice and an opportunity to be heard, there's a procedural due process violation. And in this particular instance, I guess he had notice when he was served with a no contact order, but he never had an opportunity to be heard because I don't think I agree with that necessarily, Judge Dandridge. He did have an opportunity to be heard. He was questioned about all of these things in the hearing panel. He admitted to the outcome. Well, he couldn't confront witnesses. He couldn't confront those witnesses because they didn't want to appear.
Okay, but he also wasn't disciplined for that.
But he was sanctioned for it.
He was sanctioned for his treatment of the two victims in this case, and in determining what the
no, that's not what all three of the opinions state.
Well, that's not
true.
Take
into account with the sanctions.
That's with due respect, Your Honor, I misspoke earlier. Vice Provost Durham's letter does not make reference to the other cases. It's the hearing panel that did that. The vice provost letter does not make reference to any of the K-State, the Wichita, and the other two cases. She does not make reference to that in her ultimate sanctioning letter. The hearing panel did,
Okay.
and the investigator did. But again, as a matter of opportunity to be heard, the appellant had full opportunity to address those things. He was questioned about them by the hearing panel, and he could have said whatever he wanted to say about it. And if you read the transcript, he was very cautious. He was
What
very
about
cautious.
what about the ability to confront your witnesses?
Well, I mean, you know, he's got to, I mean, frankly, at some point he's an advantage, right? He can say whatever he wants about it, and there's no one there to contradict him. He could have said anything about those prior instances. And he said a tiny little bit. He acknowledged being expelled or.
I'm not talking about
suspended
those.
from
I'm not
K-State.
talking about those. I'm talking about the two other no contact orders.
Okay, but he was also asked about those at the hearing and could have said anything he wanted about those as well. And so he had an opportunity to be heard about those. Undoubtedly, he didn't have an opportunity to cross-examine those witnesses. But as a matter of it being a due process violation or any kind of procedural violation, I will highlight to the court that there was never a procedural allegation raised at the district court. There isn't other than these due process allegations, there's not a due process, or there's not a procedural in terms of a violation of university policy allegation made in this case by the appellant. And so we're back to this notion of this court really being in position to dispose of a lot of these arguments quite simply by enforcing its own rules. All of these Title IX arguments are brand new to the Court of Appeals. They were not raised at the district court level. 49 times in the appellate brief, he says Title IX, and in the petition for judicial review, in the briefing on the petition for review, once. There was never in the district court.
Is it your position, Mr. Leach, that someone is not entitled to procedural due process if there was no, I mean, people before 1972, a student subject to a violation of the code of conduct wasn't entitled to procedural due process?
No, sure he is. But he's also got an obligation to follow the rules. And that's why the court has rules. That's why the Supreme Court in the case of State v. Williams told litigants and warned them that if you don't follow Rule 6.02A5 and identify where in the record this issue was raised below, and if it wasn't, then explain to this court why it wasn't, then you face the risk of having the issue be deemed waived and abandoned. This court has enforced that rule as recently as two cases in just last month. And the state Supreme Court had enforced it in the Godfrey case in exactly this type of scenario where the appellant in Godfrey ignored Rule 6.02A5 in the initial brief, and the state in its response pointed that out. And then in the reply brief, the appellant ignored it again. And that is exactly what we have here, Your Honor. We raised this in our response brief in this case and pointed out there wasn't any indication about any of these arguments, and he hadn't complied with the rule. And the response on the reply brief, zero, exactly like Godfrey. If we're going to have this rule, as the court said in Godfrey, that we're going to strictly enforce, I give you this case. Well, one of the cases I referenced, the ones from just last month in Espinoza, dealt specifically with an allegation of procedural due process. And this court said, you didn't raise it below and you got to follow the rules. And so this case shouldn't be any different. He had plenty of opportunity to raise procedural issues in the district court. He had plenty of opportunity to raise procedural issues at the administrative hearing. And these issues just weren't raised.
Oh, you still have 2 minutes and 45 seconds if you're interested. But as Judge McEnany says, we never penalize anyone for not using their time.
I mean, I'm happy to have to answer any other questions. I just say that these notions that the university doesn't understand its obligations under Title IX and its obligation to protect victims of sexual harassment, as the appellant has argued, are particularly ironic, coming from the person that the university has found responsible for committing sexual harassment. KU is aware of its obligations to respond to complaints of sexual harassment and sexual assault on campus, and that's what it did here. It responded to enforce its policies that prohibit sexual harassment and to protect victims and other students from the harassing behavior of Mr. Kamila. The evidence in this case shows that the appellant's conduct violated the university's policies. He made women scared to go to church. and scared to be on campus. And as one witness said, they were rightfully scared. That's the testimony in the hearing below. This court should reject the appellant's invitation to reweigh the evidence as to those findings, because that's what it is. Just as this court rejected the invitation on Friday, this panel rejected the invitation in the Mingus versus Kansas Behavioral Sciences Review Board case decided on Friday, the invitation to reweigh the evidence. That's not what the KJRA provides. The KJRA provides that this court is to check the record for substantial evidence that supports the university's findings, and I would submit to you the record here does that. Those findings came after a hearing that fully complied with Title IX and provided more than due process. And the notice and the opportunity to be heard, he had an attorney, he conducted cross-examination, he had the right to an appeal. Due process was provided here, and the expulsion of Mr. Kamila has made the university campus safer. The petition for judicial review was properly denied, and we respectfully ask this court to affirm that judgment.
Thank you, Mr. Leach. Okay, so Mr. Ritter, 3 minutes. Let me just set my cancel this timer. And we'll give you 3 minutes and you may proceed.
Thank you so much. Really briefly, just a couple of points I wanted to touch on. First, the idea that this was on-campus behavior, one thing I wanted to make abundantly clear. As far as Ms. Wojciak goes, there was no on-campus behavior that's being alleged. All of the sanctioned behavior occurred online, either through text messages.
I'm going to interrupt you real quick, and please refer to everyone with initials. That would be
I'm so sorry. I'm sorry. Ms. W, pardon me, occurred online and off campus. In fact, they only met in person one time, and that was 100 miles away from campus. How the university can somehow believe that that falls within their purview is beyond me. As far as for Ms. T, again, we're dealing with text messages, a few in-person contacts that occurred off campus at a church, and one instance in which my client ran into Ms. T at the campus library. Now, the university makes a lot of argument about how convenient that this happened to take place soon thereafter, him being told not to have contact with her. But they presented no evidence at the hearing or otherwise to say that this was anything but a chance encounter. And I think that if we're going to look at this in equal lights, that it should be deferred towards him that this was a chance encounter where he apologized, taken objectively, running into someone, apologizing for your behavior, saying it was a misunderstanding, you had no idea that your conduct made them feel uncomfortable, and then leaving them alone after that. Again, I believe this is the university trying to exploit that one incident, which objectively is not a problem in anything that the university would get involved in, and bootstrap that to the rest of the conduct and say that they were allowed to take the sanctions that they did.
Is it your position that none of the text messages in either case can be considered?
No, I don't think they can. I think both of the text message chains are not on-campus behavior, are not.
How do you know? I mean, what if the messages were received on campus, or what if one of the women reread the messages on campus? Is it on campus behavior?
I mean, that's a really interesting question, Your Honor, and
that's why I asked it. You have an interesting answer.
It would be interesting because then, if a message is received off campus, that they don't actually read it till they're on campus, I think it presents all sorts of problems, which is why this court needs to get involved and say, no, this is not on-campus behavior. Texting someone. Mr.
Ritter, I would bring you back again to the question and answers, which you cited to on Title IX and sexual violence, which is on the OCR website. It was published on April 29th, 2014. On page 29, it has a section. This is guidance. It says that it explains a school's responsibilities in accordance with the requirements of Title IX. On page 29, there's an entire section, F4, on off-campus conduct. And it said, is a school required to process complaints of alleged sexual violence that occurred off campus? And there's a footnote that says, although this document focuses on sexual violence, the legal principles also apply to all other forms of harassment, including stalking and retaliation. And it says, yes, under Title VII, a school must process all complaints, regardless of where the conduct occurred, to determine whether the conduct occurred in the context of an education program or activity, or had continuing effects on campus, or an on-campus education program activity. And again, it uses that the school must treat the complaint in the same manner that it treats complaints regarding on-campus conduct. And it goes on and on. I'm not going to read the whole thing, but there's a whole section in that exact question and answer, on the, Title IX website for the Office of Civil Rights that talks about, and it actually talks about texts. It talks about text and social media. It talks about the whole thing. And so it seems very clear to me, based on the guidance that was issued on April 29th, 2014, that all of this is included. Do you have any comment about that?
Yeah, absolutely. I mean, if we're talking about a text message sent to another student saying, I'm waiting for you on campus, just you wait, you're going to get what's coming to you when you get on campus. I don't think I could argue that the school wouldn't be able.
But that's not what this says. Have you read this?
I have. I don't have it in front of me. I apologize, but I have read it. What I don't think, though, is that it gives the school carte blanche ability to intrude into behavior that takes place off campus just because it happens to be text messages. I don't think that's what the question and answers were outlining. I think
right, because in the code of conduct says that if the off-campus conduct affects, the student's education on campus.
And that's why I think it's important that we realize from their intent behind that we're talking about the effect would be so great that it would either be injury or causing them absences from class.
But when you did quote that, you left off the whole paragraph that she said before that. The expanded jurisdictional language permits the university to address, that was yours. But before that, it says, the intention of the jurisdictional expansion for 2016 to include off-campus conduct is to address the needs of the students who have been subjected to such intense, that's yours, okay. It permits the university to address significant on-campus issues that threaten the health and safety of our community, as well as students' rights to participate in the educational process. And that paragraph precedes the paragraph with the intense violence that you said. So you selectively included only the intense violence from that letter, and you did not include the paragraph preceding. So that.
I appreciate your Honor pointing that out. I guess I would go back to the idea that even if this court were to consider those text messages from an objective standard, I don't think the university can point to anything in those text messages that rise to the level of harassment that would allow for expulsion.
Okay, if you would like to take a moment to sum.
Yes, just briefly. I think we have to go back to realizing that what we're dealing with here is a person who's awkward and a person who may not appreciate social cues, a person who may have made people uncomfortable unbeknownst to them, but for the university to get involved in what is predominantly off-campus behavior, bootstrap it to one on-campus incident, which can be boiled down to an apology, and then expel him based upon all of that, I don't think is appropriate and is something for this court to unwind. Thank you.
Thank you. Thank you both, all three of you, counsel. We really appreciate you making yourselves available for this. We will take the matter under advisement, and again, we'll try to get something out within 30 to 60 days.
Thank you so much, Your Honor. I appreciate it.
Thank you. Court is adjourned.